I'd like to welcome you to today's discussion on public access to federally funded research, copyright, and other issues. This event is being put on by the ABA's Committee on University Intellectual Property Law, and I'd like to thank the Law School and the Cyber Law Clinic for hosting us and for their help with the arrangements. We're fortunate to have two distinguished panelists with us today. On my second to the right is Mark Seeley, who has been the Divisional General Counsel for Elsevier since 1995 and has helped support the transition from a print journal to an online database model and the transformation from an almost exclusively hard sciences journals business to a more diverse science and medical publishing and information services business. He serves as the chair of the STM Association's Copyright and Legal Affairs Committee, which recently released an industry text and data mining model license. Mark is the co-author of a chapter on copyright issues in a forthcoming book, Academic and Professional Publishing, that will be released in September 2012 by Chandos Press.
Publishers are very slow. That's my conclusion.
On my immediate right is Peter Suber, who is the director of the Harvard Open Access Project, a faculty fellow at the Berkman Center for Internet and Society, special advisor at the Harvard Office for Scholarly Communication, senior researcher at Spark, research professor of philosophy at Earlham College, and a non-practicing lawyer on top of all that. He writes the Spark Open Access newsletter, was the principal drafter of the Budapest Open Access Initiative, and sits on the board of Enabling Open Scholarship, the advisory board of the Open Knowledge Foundation, the advisory board of the European Library, and the boards of several other groups devoted to open access and scholarly communication. He's been active in promoting open access for many years through his research, speaking, and writing. Also with me at the table is Simon Franzini, a third-year student at the law school who's been working on a cyber law clinic project on the topic of today's panel. I'm Jonathan Hulbert, a university attorney in Harvard's Office of the General Counsel and the vice chair of the ABA Committee on University Intellectual Property Law. Today, we will be discussing free online access to papers resulting from federally funded research, as is currently required by the NIH Public Access Policy and will be required by the Federal Research Public Access Act if that pending legislation is adopted. We'll refer to that pending act as FERPA, not to be confused with the Family Educational Rights and Privacy Act, which is also known to us at the university here as FERPA. So we're going to start out with a brief description of the NIH Public Access Access Policy and FERPA by Simon to provide context for any of you who are not already familiar with them. We'll then turn to a discussion between Mark and Peter. One can debate the merits of the NIH policy and FERPA on policy grounds, and I expect that today's discussion is going to carry us into that territory. But our focus is on copyright and legal issues. Some have argued that the NIH Public Access Policy and FERPA are inconsistent with copyright law and copyright-related treaty obligations of the United States. On one formulation of the argument, the NIH policy and the Act are inconsistent with the letter of the law and those treaty obligations. That is, the policy and/or the Act or their implementation violate copyright law or treaty obligations. On another formulation, they're inconsistent with the spirit of copyright law and treaty obligations. I think the latter view is closer to Mark's, but we will let him tell us about that.
All right. Someone else just joined. I'm connecting
I'm
you
going to,
now.
after Simon's introduction, ask Mark to give us a brief description of his view about the copyright and treaty issues. And then Peter will have a chance to state his view. And from there, I hope that a conversation between Mark and Peter will unfold. Toward the end of the hour, we'll open the floor to questions. Those of you who are participating remotely can email questions to publicresearchaccess, all one word, no capitals, no spaces, @gmail.com. That's publicresearchaccess@gmail.com, where Simon, who's manning a laptop, will field those questions. If there's interest in continuing the conversation past 1 o'clock, Mark and Peter both graciously agreed to stay over a little bit, but there'll be an opportunity for those of you who need to leave at 1 o'clock to do so. So with that, let me ask Simon to give a quick description of the NIH Public Access Policy and FERPA.
All right, thanks, Jonathan. So I'm going to start with the NIH policy. So the NIH policy, which took effect in April of 2008, guarantees a form of open access to the results of NIH-funded research. It requires grantees to submit a final version of any manuscript accepted for publication in any peer-reviewed journal arising out of an NIH grant-funded research, and has to be submitted to a digital archive known as PubMed Central. Manuscripts that are archived in PubMed Central are made accessible to the public online and free of charge within 12 months of publication. Turning to FERPA. FERPA is a bill that was recently introduced in both the House and the Senate, and it would require federal agencies with extramural research budgets over $100 million to provide open access to publications stemming from the research that they fund. Specifically, it would require these agencies to make final peer-reviewed versions of any manuscript arising out of agency-funded research available to the public free of charge within 6 months of publication in an academic journal. If passed, this act would affect 11 agencies.
Okay, Mark, do you want to start us off?
Happy to. And yes, I think I'm going to come down on the spirit and not the letter for the reasons that I'll try to articulate and spell out here. So in terms of the spirit, I do think that copyright law and U.S. copyright law is really about providing protective rights for copyright works to ensure their incentive to be created, to be produced, distributed, and curated, with the understanding that such rights will provide an appropriate investment to make such works accessible and available. We often talk about balance in copyright law between that incentive for creativity and production and the public good in general. But in my view, that public calculus should also include things like fair use in its primary sense, with respect to quotation, criticism, education, the idea-expression dichotomy, de minimis copying, and the like, which I believe is exactly what the Supreme Court has just talked about in its discussion in the Golan case about the traditional contours of copyright. But I do agree, of course, that express limitations and exceptions also play a role, and I'll talk about that a bit more with respect to treaty obligations. My view also is that the market conditions for scholarly journal content, which is that they're easily accessible for most academic researchers, accessible through interlibrary loan, document delivery, and rental models for most others, that is the market that we have to consider when we talk about exceptions and limitations. So having said all that, I do agree that technically there is nothing in U.S. copyright law that would prohibit a funding agency, or for that matter a private foundation, from placing conditions on a grant that might implicate rights under the copyright bundle. For that matter, the National Endowment of the Arts could make similar rights-limiting conditions on its grants. What I think is less clear is whether those restrictions could or should apply to other participants in the creative process who are not in privity with those respective agencies. Consequently, I argue that NIH grant conditions could not and should not apply to versions of articles that have benefited from the contributions of other players, including publishers and their production teams, editors, and reviewers. The difficulty with this position is that it is not always clear which versions have benefited from such contributions and in what fashion. Different articles in different journals will have varying levels of such contributions. Going to the question of treaty obligations, I do think that the principles that are generally set out by advocates for the OA policy at NIH do touch very much directly on traditional exceptions and limitations for research and scholarship. And that's a classic area that, of course, should be guided by the Berne Convention and three-step test with respect to international treaty obligations. Being subject to those kinds of analysis would mean a real-world analysis as to the specialness of the exception and its impact on market conditions. It's possible, of course, that the NIH policy could meet such a test, but in my view should be subject to that legislative analysis and discipline, which has not, in my view, happened yet. So back to the legislative bills, and I'll focus mostly on the RWA. In my view, the RWA and its predecessor bills were very much about that additional value provided by professional publishers and others. The bills asserted that those versions of journal articles which have gone through the processes of peer review, editing, formatting, and other production values represented an additional contribution to the original paper that should not be subject to the original grant processes. This distinction between final versions and pre-final versions is also consistent with green open access policies that Elsevier and many other publishers follow, by which the authors may elect to post preprints and other pre-final versions on preprint servers and other sites. Or perhaps I should say consistent with the original context in which Green OA publisher policies developed, which dealt primarily with preprint servers and author sites. None of the controversies between the NIH and the scholarly publishing community would have come about if NIH would have accepted preprint versions of articles, or if NIH had agreed to follow a linking policy which would take users to journal versions on publisher sites. Instead, the NIH insisted that the value add of peer review comments accepted by authors and editors in particular were critical to making the PMC project successful and should be hosted on PMC. In my view, the NIH, of course, is right to believe that PMC is more successful as a research tool because it includes versions of articles that are closer to the final version than preprint versions would be in many cases. But that, of course, is the point the publishing community was making. If I go back a little bit to the formulation under the budget authorization bill by which the current policy was implemented in legislation, the publishing committee did feel at that time some vindication with respect to the reference to copyright, which was included in that bill. Many believed that this would suggest or encourage the government to negotiate methods by which some competitive space and distance for journals, which relied primarily or exclusively on the subscription business models or linking models, along with the government's stated intentions with respect to public access and accountability. I think we contemplated a system that would focus more on abstracts, on preprints, on support for projects undertaken by medical societies to prepare more consumer-oriented versions of research papers. Instead, NIH regulations made a requirement for distribution, always understood as a key aspect of copyright, as a burden or a lien on resulting papers. Many publishers felt that this underscored the NIH's determination to create a competitive research platform that would be a first port of call for researchers. This is, in my view, exactly what NIH aims to do and has done, and I do not think they would deny it, although they would also say that such a system serves a broader public need. Some argue that there's no harm to the journal business model in having some articles accessible without charge, although that is something that's very difficult to measure in the short term. In the longer term, and if the NIH policy expands to other agencies in other countries, it will be impossible for there to be no impact. Some journals publish a majority of papers from federally funded research programs, and certain disciplines will have a larger number of such papers that are connected to such funding than others. These disparate effects are the reasons that journal publishers have called for more dialogue and more flexibility. Many publishers were directly involved in the OSTP processes under the America Competes Act and hope that more progress can be made there with more nuanced approaches to the question of public access and embargo periods. The publishing community has also challenged NIH and other agencies and governments to be more directly supportive of author-pays business models if the agencies and governments intend to change business dynamics in such a fundamental way. Publisher business models are varied, from full author-pays to subscription models, to hybrid models, and to models that depend more on driving traffic to websites and monetizing there. But ultimately, the model does not matter, provided there is a sustainable method to support journals and investment. If there isn't, then the incentive to invest and curate is diminished, which I believe will diminish society as a whole. I also suspect that in the future, with such a diminished role for professional publishers, at some point in time, that role will have to be reinvented, as there are probably many good reasons why the academic world has outsourced some of those activities in the past. So I hope those remarks have clarified and put in context the legal and technical issues. I am a strong supporter of copyright, as you've heard, and I do believe that it's a tremendous vehicle that has worked incredibly well to gain access to a broad range of knowledge. Publishers are in the business of facilitating the awareness of research and its implications and working on access models to make that happen. Finally, what we believe is that there is a broad public interest in identifying real access gaps and working constructively to narrow and close them. Thank you.
Mark, do you want to? I'm sorry,
Peter.
Peter, do you want to take it?
Thanks, Mark. I could read a few prepared remarks, or I could respond to some of the points that Mark just made. First, I'm glad that Mark distinguished the spirit from the letter of copyright law to help sort out these issues. It sounds like Mark is conceding that the NIH policy does not infringe copyrights. Is that true?
I think it's, as I said, it's difficult to determine what the additional value add is, which makes it difficult to imagine the appropriate sort of legislative approach to that, which is, I concede, one of the problems with the RWA bill.
I want to get back to that, but does everybody know what the RWA is? It was not part of Simon's introduction. The RWA is the Research Works Act. It was also introduced in the House of Representatives this session by a Republican and a Democrat. It had bipartisan support to that extent. It has been withdrawn by both supporters. Elsevier originally supported it. Elsevier has also withdrawn its support. So in a way, it's a dead bill now, but it raised some copyright issues that we could still talk about. It would have, this is my paraphrase now, directly repealed the NIH policy by prohibiting the method used by the NIH for avoiding copyright infringement. The NIH avoids infringement by asking its grantees to retain certain rights, in particular the right to authorize open access. And the bill would have prohibited funding agencies from requiring that sort of rights retention as a condition of funding. It also would have required publisher consent for any open access, even if the author had retained rights and given consent. In other words, it would have required an additional consent from a non-rights holder on top of the author's consent. But the bill is now dead. I'd be happy to talk about that, but we could also talk about NIH and FERPA. Since many publishers have said the NIH policy is inconsistent with copyright law, I'd like to clarify what Elsevier's position is. Elsevier has not said the NIH policy infringes copyright. And if it doesn't infringe, then we can talk about what inconsistency amounts to. But first, I want to find out whether it does infringe. In your opinion, Mark, does the NIH policy, by asking authors to retain rights, certain rights, and use those rights to authorize open access, infringe copyright?
So in general, I think the NIH had a number of avenues by which they could have perceived down to this question of complying with copyright law.
Yeah.
This is one method that they've chosen. I don't think it's a wise method, but I can see that it probably does not violate U.S. copyright law. I'm less sure about the treaty question and the exceptions and limitations, but that's also a more difficult issue and be more difficult to challenge it because you have to challenge it in an international context.
Right. Okay. I'd be happy to talk about the treaties, but it sounds like we agree it does not infringe U.S. copyright law, even if you would have preferred the agency to have adopted a different method for avoiding infringement. This method works. This method is to ask authors to retain rights and use those rights to authorize open access. In that sense, open access is authorized by the rights holder, by the relevant rights holder. There's another consequence I'd like to make explicit, which is that the papers that result from NIH funding are not owned entirely by publishers who publish them, even if the publishers ask for a full transfer of rights. The authors retain some rights, and they never give those to publishers. Publishers never acquire the full bundle of rights, and therefore, these works are jointly owned by the authors and the publishers. The NIH requires the authors to retain one right, which it calls a small sliver. We can disagree about how big a sliver, but to retain at least one right, and the author may and typically does, transfer all the other rights to a publisher. But the result is divided ownership, not unqualified ownership by publishers. And the right that...
Not sure why you say that, Peter. In the traditional model with the copyright transfer, what rights exactly would have been retained by an author in the traditional model before NIH?
Often none.
Okay.
That is, it used to be the case that publishers could acquire full copyright, the full bundle of copyright. Authors would have retained nothing. But under NIH, the authors do retain a right. Publishers don't acquire exclusive rights. And if we understand that ownership is divided, then we can talk, I think, with more nuance and accuracy about whether there's any taking going on here, whether the government is interfering with the market, whether it's interfering with the spirit of copyright. The spirit of copyright includes the right of copyright holders to retain the rights they want and to transfer the rights they want, to divide the bundle if they think that's in their interest. It's not simply to transfer the whole bundle to publishers because that has been customary.
Agree?
Yeah, okay, good. So that's one way to approach the spirit aspect of the argument. But on the letter, it sounds like we agree that the NIH policy does not infringe U.S. copyright law. I'll just start to talk about the treaties for a minute. I'm not an expert on the treaties, but it seems to me that the treaties only come into play if the NIH policy amended copyright law in a way that affected the acceptance and limitations. But it doesn't do that. There are a couple of reasons to think so. First, it doesn't amend copyright law at all. That was part of the legislation. FERPA, by the way, also includes an explicit clause saying nothing in this bill shall be construed to amend copyright or patent law. Secondly, the NIH policy doesn't change fair use. It doesn't change the duration of copyright. It doesn't change any of the acceptance and limitations. It is about the contract with the grantee. And the contract with the grantee used to be silent on what rights the grantee had to retain when the grantee went to publish. But now the contract is not silent on that, and it says when you go to publish work based on NIH funding, you must retain certain rights. And if your publisher doesn't want to let you retain those rights, then you must look for a different publisher. That's a contract issue. It's not legislation. It's not about exceptions and limitations. And the treaties say nothing about the contracts between the original copyright holder and any licensee. And if the treaties are silent on that, then the author, who is the original copyright holder, may divide those rights any way that author wants and transfer some to the NIH and retain others. I don't think the treaties then come into play.
Well, the way that the treaties would come into play would be, I suppose, with respect to the question of foreign rights and rights holders, and perhaps where there's a division of authorship, for example. So that could be the factual circumstance under which an allegation could be made that there's a violation of Berne in terms of its impact and effect.
I concede that multiple authors makes this policy complicated. If it's well implemented, then the NIH-funded author in a group of co-authors should inform the other co-authors that because of the NIH funding, the peer-reviewed manuscript will have to be made open access through PubMed Central. By the way, the NIH policy says this applies whether the work is funded in whole or in part by the NIH. So it would apply to all the co-authors. The other co-authors ought to know about that. When there's a solo author, the policy works because it's a consent issue, it's a contract issue. You don't have to apply for NIH funding, and if you do, it comes with this string, and if you don't like the string, you don't apply for NIH funding. But if there are multiple co-authors and not everybody's clued in to the terms of the policy, then there could be a problem, and some co-authors might find that their work is becoming open access when they didn't intend it to. So to me, that's an implementation issue. If it turns out that that's happening, it can be prevented, it ought to be prevented, but it's prevented through consent. You simply inform your co-authors that this is true. And by the way, Harvard has a version of this policy, and the same thing would come up at Harvard. If a Harvard author co-authors a paper with someone from another school, the Harvard policy applies, and the Harvard author has a kind of duty to inform the co-authors that the policy applies and that this consequence will follow. But as I say, if it's not happening that way, if some co-authors are being surprised, I'd like to see that fixed. That would be a problem.
I think, again, going to the spirit question, so what I think is indisputable is that the NIH has its controls and manages a very significant slice of research funding. It would actually be quite difficult, I think, for a researcher that is well-known, doing lots of research in fields that NIH funds, to sort of not look at NIH funding as being an important source. In the same way, of course, journal publishers are often going to be very interested in the possibility of publishing an article that results from cutting-edge research that often emanates from this kind of funding. So there's lots of pressures on all parties to conform, which is, I think, a good reason why greater flexibility and more nuanced approaches should be encouraged.
There's one other form of pressure we should put into the equation, which is that Elsevier controls many of the most important journals in many fields, and many authors, for the sake of their career advancement, feel they must publish in an Elsevier journal, and the idea that they might not be able to because Elsevier won't let them comply with their prior funding agreement would exclude them from the journals that might advance their careers. So authors feel pressure to publish in Elsevier journals. Elsevier feels pressure to publish NIH-funded authors because the quality is good and the quantity is high. And NIH feels pressure to provide open access because it's dispersing public funds and it owes the public the benefit.
Peter, I hate to correct you in a sense, because I like the idea that Elsevier publishes all or most of the best journals, but in fact, it's a fairly varied market, and many of the better known journals are not, in fact, published by Elsevier, but we could
I'm happy to concede the point. But it is true that in some fields, authors don't have many high-quality, high-prestige choices beyond Elsevier. You may know that there's a boycott of Elsevier journals now by mathematicians, and I've been reading the blogs by many of the people participating, and some of them find it hard to participate because Elsevier journals in mathematics are among the best, and in certain subfields of mathematics, Elsevier dominates. Elsevier dominates, that is, it tries to. It's success for Elsevier to do so. So it shouldn't be surprising that Elsevier does in some cases and then aspires to do so in other cases. In any case, the pressures are on all sides. And I want to talk about these pressures in a slightly different way right now for a second. Mark talked about versions, and he said the controversies wouldn't have come up if Elsevier had only asked for open access to preprints, non-peer-reviewed versions. But instead, it asked for open access to the peer-reviewed versions, which have been modified by Elsevier or by referees organized by Elsevier. That's true, by the way, I concede that. And the policy does that precisely, as Mark said, because it makes the resulting manuscripts more valuable. The peer-reviewed version is superior for research purposes than the preprint version. And Mark emphasized the privity of contract issue. That is, the funder has privity with the grantee, but not with the publisher, and that's true too. But NIH does not regulate publishers. It only regulates grantees. It doesn't tell publishers, you must provide the peer-reviewed version to PubMed Central. It tells grantees, you must ask for these terms when you go to publish. So when those grantees go to Elsevier journals, they ask two questions instead of the traditional one. They ask, will you publish my article? But they also ask, will you publish it under these terms? I'm bound by my prior funding contract, and I'm bound to ask for these terms. Will you publish it under these terms? That's when Elsevier has the freedom to say yes or no. If it thinks that letting the peer-reviewed version become open access will create business risks for it, then it can say no. And by the way, so can any other publisher. And to date, 100% of publishers in biomedicine, the area of NIH, have accommodated the policy and agreed to publish under those terms. So my short answer is, if this ever becomes too risky for a publisher, if it looks like the losses will exceed the benefits, they have the remedy in their own hands. They can just say, we won't publish. Now, if they are accepting these deals today because NIH funded research is such high quality and so voluminous that they would lose if they didn't, that's a way of saying, right now, the business benefits exceed the business costs or the business risks. That's a good reason for us to accept this as a solution to the problem. Until now, until the NIH policy backed authors, authors had no bargaining power with Elsevier journals. If they said, I want my article to be open access, Elsevier would say, essentially, take it or leave it, this is our contract. Now, authors have the bargaining power of NIH behind them, and they say, I must ask for these terms. In fact, if you don't accept these terms, I must look for another publisher. So now we have authors asking for better terms and having more bargaining power to get those terms than they used to have. Elsevier always had the power to demand certain terms, and it had the power to get them in almost every case. So what seems to me is going on is hard bargaining, not anything inconsistent with copyright law. Elsevier has always been able to exert its market position to get authors to comply with its publishing agreements. Now authors are in a position to push back and say, if you don't give me the terms that I need, then I have to look for another publisher. And suddenly author bargaining power is roughly equal to Elsevier's bargaining power. And when we see the result, it's not that Elsevier is going out of business. On the contrary, Elsevier's profit margins have gone up steadily since the NIH policy was adopted. So I don't see the economic loss. And if there becomes, if this changes, and Elsevier starts to lose more than it gains from this, Elsevier can back out anytime it wants.
So I think that it's an interesting formulation, but to tell you the truth, the way that I truly see it is that this is the NIH exerting quite a bit of leverage for its own purposes. Now, those purposes may be largely beneficial, but they are competitive. And I think to some extent, authors generally do get stirred up about the idea, of course, making their works available and accessible. They want them indexed, so that's an important motivation on the part of authors. But I'm not sure that authors left to their own devices would decide that putting papers into an NIH repository and subjecting it to other types of database uses would be the thing that they would, in an ideal world, want to do. I do think that's what NIH intends to do.
Mm-hmm. It's true that NIH has its own interest in open access, but I think authors do as well. One way that open access advances is that other institutions with their own interest in open access are giving authors greater bargaining power when talking to publishers. If authors had to do it one-on-one, they would generally lose. And this was the case until about a decade ago, when most publishers were inflexible in modifying their publishing agreements, and since then they've become more flexible. But universities have an interest in open access, funding agencies have an interest in open access, and together, universities and funding agencies are in a good position to influence author decisions, and also to educate authors about their own interest in open access, which is authentic and growing. So it's a convergence of interests. It's not as if NIH is doing this at the expense of authors or in violation of authors' interests. They are doing it with authors. Some authors understand they have an interest in open access, some don't, and they're simply complying with their funders' request. But there's no doubt NIH benefits from this. However, we should make clear, NIH is not benefiting from this as a private interest. It's benefiting from this as an agency of the government acting on behalf of the people and the public interest. It's benefiting by providing the results of publicly funded research back to the public.
Can I interject a question, which is, so I think you've drawn an important distinction, Mark, between preprints, that is, articles that have been submitted but so far not reviewed or modified through the peer review process, and the author's final manuscript, which does reflect the changes from the peer review process. And I was wondering how there's one more step on the continuum, which is to the final published version. And one way, at least I think, of looking at the NIH policy is that the NIH tried to strike a balance between the interests the agency has in public access to research results on the one hand, and the interests that publishers have in the continuing viability of a subscription-based model of publishing, by both requiring that it's only the final manuscript that be deposited in PubMed Central versus the final published version of the article, and also by allowing an embargo of up to 12 months. And so I was wondering if you would comment a little bit on whether you see a meaningful distinction from the standpoint of competition and the possibility of a subscription-based model continuing to coexist with PubMed Central, whether you see an important distinction between the published version and the final manuscript, and how you view the embargo.
So as what one of my colleagues in talking with the UK government recently talked about, so let's say there's a precipice somewhere, and we're getting close to the precipice, and so far you haven't fallen down the precipice, so everything is okay. But Clearly, at some point, as you get closer and closer, you will fall down the precipice. So I accept that indeed NIH has had some balancing of interest that they did. I think that they felt generally that getting some pre-final version that had the peer-reviewed comments accepted by the author was an appropriate balancing spot for them. And I think they felt that it was clear and it sort of, facilitated the public interest as far as the research article goes. I'm still personally not convinced that research articles actually advance much with respect to the public's understanding of science and the research that's done by NIH. I think there are other methods for doing that that are probably more effective, but I don't discount that there is a public value in the posting the preprint version, the print version, the version that has the peer review comments. So except that there's some balancing there.
And do you see the publisher's competitive interest to some extent protected by having the exclusive right to distribute the final published version with whatever additional value is being added by the publishers after the peer review process, or is that actually not really a meaningful distinction?
I think, again, going back to sort of what publishers collectively would, most of them in it, would like for the NIH policy and the database to look like, that database would acknowledge and would link back to the publisher's sites more often and in a more direct way than it does now. And I think that doesn't mean that some version of the article wouldn't be available on PMC, but that it would be clearer to folks coming to the site that the final version is hosted and located elsewhere. And I think that a database that looks more like that and acknowledges more of that kind of community contribution would be much appreciated and would take out some of the heat that's currently in the debate.
Do you want to say anything at all about the embargo period? I'll then ask the same set of questions of Peter.
Well, I think in terms of embargo periods, it is kind of ironic considering some of the controversies over copyright duration of a few years ago that now we're talking about whether it's 1 year, 18 months, 2 years, or 3 years. But those are the kinds of debates that we're having in this field. And I think what we have focused on at Elsevier, but I think other publishers are thinking along the same lines, is a way of identifying which disciplines and which journals within those disciplines are going to be more affected by varying embargo periods, and whether we can put that kind of nuance and flexibility into these public policies.
Peter, do you want to speak to either of those points?
Yeah, there were many small points. Let me pick out one first that we haven't talked explicitly about, and that's the audience of lay readers or non-professional researchers. Mark was unsure that the NIH policy benefits them much, and there is uncertainty about that. We don't have a good way to measure that. I'll only point out that it's not the purpose of the NIH policy to address lay readers specifically. It's to address everybody who might have an interest in these papers, whether they happen to be professionals or non-professionals. I would say the primary beneficiaries of the NIH policy are professional researchers who need access for the sake of their professional work, researchers who don't have access through their institutions or who don't work at institutions. But there turns out to be quite a large lay demand for cutting-edge peer-reviewed research papers, larger than I think all of us expected, publishers and open access advocates alike. We see this, for example, PubMed, when PubMed created PubMed Central and started creating open access to its papers. Its traffic went up over 100-fold, and most of the visitors are from non-EDU domains. And this is big, this is exciting. This shows that there is a public demand that had been unmet. It's also showing that these publicly funded agencies can serve that demand with a policy like this. But to me, the case for open access does not depend on what the percentage is of lay readers and whether there's a high or low demand there. The public deserves access whether we distinguish professional readers from lay readers or not. And even if 100% of the usage was by professionals, it would still be justified policy. And there's uncertainty on some of the other questions that Jonathan asked as well. Does it make a big difference to distinguish the version that was peer-reviewed but not copy-edited from the version which was both peer-reviewed and copy-edited. We do make that distinction, and we only provide open access to the former, not the latter. And the idea is to provide a concession to publishers and preserve an incentive for libraries to subscribe. Does that work? Does that create many subscriptions that we wouldn't have otherwise? I don't think we know the answer to that. Or to put it another way, if anybody has the answers to that, it's publishers, and we don't have the data in public to examine. And then likewise on embargoes, I think we can all agree that the demand for articles falls off at different rates in different disciplines. And if protecting publisher revenue were the rationale for embargoes, then we would probably want different or differential embargoes in different fields. I'm not sure that would be justified, but insofar as we were trying to protect publishers, that's what we would do. But instead, there's another interest at stake here, which is providing timely access to the public which paid for this research and for those researchers that don't already have access through their institutions. And they need access whether, that is, they need timely access, whether it would hurt publishers or not. So on the one hand, I want to say, let's stick with these policies because they're in the public interest. Let's monitor their effects on publishers. If it turns out that this particular version on this particular timetable harms publishers, then as the evidence comes in, we can think about tweaking the policy to reduce that harm. But when we think about it, we won't automatically reduce the harm because the public interest will still be there in providing access to everybody who paid for the research in the first place and who could benefit from it.
So I agree, actually, that the public's interest in much of this material and a lot of other professional literature is probably surprisingly high and probably surprised a number of publishers as well. I remember when we were first putting more of our reference works, for example, available on Amazon.com, and frankly, I don't think we expected to have very much sales or interest there, and we've been pleasantly surprised. I accept that that does happen. I also accept that there is an access gap with respect to unaffiliated knowledge workers, and it's good to be trying to figure out ways to solve those gaps. But to the public value and the utility question, I really do think that NIH could have decided to devote some time and some resources to other ways of informing the public, to publication of research reports, to publication of data, to publication of more user-oriented material that describes what's going on in the research. Instead, it seems to me that they focused exclusively on this online database tool, pretty much to the exclusion of those other avenues. So it serves a public interest, I accept, but it's not the only thing that would have served the public interest.
That's right. It could have picked a goal which would have served the public interest less, and I don't think we should criticize it for picking the goal that serves the public interest more. It happens to be, for the same reason, one that carries greater risks for publishers. But as I say, publishers have the means within their own hands to limit those risks whenever they want to. They don't have to publish NIH-funded authors. In the rhetoric of the publishing lobby, I'm distinguishing that from publishers. We often hear the term unfunded mandate. The NIH policy is an unfunded mandate. It sounds good because it's a kind of mandate, and it sounds good because there's no funding there. The NIH does not compensate publishers for the expense of organizing peer review, and yet it's hosting the peer-reviewed copies of the articles. But it's not an unfunded mandate because the mandate is to the grantee, not to the publisher. And the publisher is free to step back and say, for us, the cost would exceed the benefit. We don't have to publish NIH-funded authors. And now that we've done the calculations, we won't. They're completely free to do that. If there were a true mandate to publishers, they would not be free to do that, but they are. And by the way, one concession I'll make is that publishers ought to have forever the right to refuse to publish any work for any reason. They do now, and I don't want anything to jeopardize that. So publishers can exercise that right to refuse to publish NIH-funded authors and completely free themselves from any risk that they perceive to lie in the policy, even if, that is, regardless of their calculation. They could have good or bad grounds for believing it's risky for them and still pull back because they're free to do so. So in that sense, we're overlooking the role of publisher consent. We talked about author consent, grantee consent. You don't have to apply for NIH funding. If you do it with your eyes open. You take all the terms and conditions that come with the grant. But publishers do the same thing. And when the grantee comes to the publisher and says, I must request these terms under my prior funding agreement. Will you publish under these terms? There's publisher consent there. The publisher could say no, but if the publisher says yes, the publisher has no right to complain. The publisher should.
It's America, we can always complain.
Okay. If it's that kind of complaint, now we know where to put it. The consent component takes this completely out of the category of takings, seizures, commandeerings, and by the way, these are all terms used in the lobbying against the NIH policy. The NIH commandeers articles. The NIH policy forces publishers to surrender their articles. The NIH policy is a taking under the Constitution. It's none of those things when there is publisher consent, and this never happens without publisher consent. It's publisher consent under terms of hard bargaining, but the traditional publishing contract was author consent under terms of hard bargaining. So you can't have it both ways.
You want to respond to that, or I'd let
Well,
them
we'd
go
like
for
to
the
publish
subject.
really high-quality articles, so there's considerable leverage, as I would say. So whether you call that a mandate, I think it's pretty darn close to one, but in any event.
I call it hard bargaining.
I think so. But there's another aspect that I think we haven't talked about that I just wanted to mention briefly, which is in terms of who's the beneficiary of the policy. Because there's another large class of beneficiaries who are actually commercial corporate researchers, particularly for a fair amount of research that comes out of NIH, which we don't actually talk about. And the issue there is that, of course, those companies are not the primary subscribers or accessors of the research literature. That's probably university and research institutions themselves are number one, but they're not insignificant. So one aspect of the policy that we don't often talk about is that other class of beneficiaries, which is not sort of the general public, and which does have a fairly strong commercial motivation in terms of obtaining the research and using that in their research for things like new steel alloys, well, that wouldn't be NIH, but, and new pharmaceutical products, so.
I agree with that. We don't have a good measurement for how many subscribers to subscription-based journals are not academic, but many research-based industries subscribe to these journals. One estimate I've seen is about 30%, but the person who made it was admitting that it's just a guess. But let's say it's 30% for the sake of the conversation. If it's 30% and all these papers are made open access, and if that open access causes the cancellation of subscriptions, which has not yet happened, then the industries will be canceling along with universities. And the industries have been willing to pay up until now, by the way, so have universities been willing to pay. And I think the fear is that we will leave money on the table if we start to give something away for free to industries that were willing to pay. To me, the same argument could be made for universities that is being made for industries. Universities have been willing to pay up to a point. Of course, they make cancellations every year for budgetary purposes. This is true even at Harvard, with the largest library budget in the world. Well, every kind of subscriber has to cancel for budgetary reasons as time goes on, as budgets stay flat or decline, and as prices go up. And by the way, we haven't mentioned that prices have gone up 2 or 3 times faster than inflation for 2 or 3 decades. I mean, it's reached unbearable levels. But the final consideration, I think, is that there's no free rider in those industries, any more than there would be a free rider in the academic side. There's no free rider if the work is deliberately open access. Broadcast television is free for the end user. We don't call the end user a free rider just because they're getting it for free. We intend to give it to them for free, so when they take advantage of the gift, we can't criticize them for it. We intend to make it available to the research-based industries just as we intend to make it available to universities. If the result causes cancellations because there's less money in the system and institutions formerly willing to pay subscriptions are now canceling, then, as I say, we can start to rethink. But so far, those cancellations have not happened. Let me just give a little more background on this. Earlier, Mark used the term green open access. I'm not sure everybody knows what it means. It's open access not through journals, but through repositories. And that's what the NIH policy does. These works are still published in journals, like Elsevier journals. And the question is whether the rise of green open access will cause cancellation of the journals in which the same articles appear in different versions on a different timetable. Green open access has existed for the longest time in physics. That is, it's existed since 1991, which is almost ancient history in internet time. Green open access is almost 100% in some fields of physics, like particle physics. And there's no other field in which green open access has such a high level of participation for such a long period of time. And if high levels of green open access caused journal cancellations, it would have happened first in physics, especially those subfields where the rate is about 100%. But it has not happened. In fact, the American Physical Society and the Institution of Physics have both said in public, we don't detect any cancellations that we can attribute to the rise of green open access. So there's good reason to think that for quite a long time, there will be no cancellations due to the rise of green open access. We don't know what's going to happen in 30, 40 years, but in the 20 years that this has been happening in physics, there have been no cancellations. And if true, where's the harm? There have been 3 congressional hearings on open access, and in each one, publishers were directly asked by members of Congress, can you detect any harm from the NIH policy, that is, cancellations? And in every case, the publishers were unable to point to any cancellations. They were able to point to decreased downloads, but not to decreased cancellations. And the decreased subscriptions. Decreased downloads have not yet translated into decreased subscriptions. The physics publishers have said they don't attribute any of their cancellations to the green open access policies. Other publishers haven't quite said that, but the data seem to suggest there are no cancellations attributable to green open access, because if there were, the publishers would have mentioned them at the congressional hearings where they were directly asked about them.
Let me, I'd like to give you a chance to respond, and then maybe
Yes.
we can
One
open
quick
it.
thing on physics. So, however, it is true that physics journals are publishing fewer papers, I believe. So,
Fewer
I'm
than in
not-
the past, you mean?
yes, I'm not quite sure what that suggests about archive. It may suggest that some data and some preprints, when published on archive, diminish the need for further publication,
Yes.
perhaps. So it is having at least that impact. Plus, I mean, in certain fields in high-energy physics in particular, there's a bit of a question about how much peer review can be done and by whom, so.
That's true, I'll concede that. Physics, especially high-energy physics, is unique in that most of the results are done on very, very expensive equipment. And the only way you can get your hands on that equipment is to go through a layer of peer review. And basically, we want to hear the results of those experiments, regardless of what any publisher has to say about it, regardless of what peer reviewers subsequently have to say. So in a way, the important level of peer review was already done, and the preprint is as valuable as any postprint. However, archive also takes postprints, not just preprints. And not only do the APS and IOP say they have detected no cancellations attributable to open access, they actually host their own mirrors of archive, the Green Open Access Repository for Physics. And they accept submissions from the repository. In other words, they're symbiotic with it now. They don't feel that it's a threat whatsoever.
Ask if anyone would like to pose a question to our panel.
Thanks. I'm Karen Markin. I'm a research administrator at the University of Rhode Island, and I'm interested in what Mark's idea about alternative ways to get the word out to the public might be, because we were talking about unfunded mandates, and it would be an unfunded mandate to put the work on the investigator, you know, the scientist, or on NIH. If NIH has got to write up like abstracts for the layperson, someone's going to have to do it, and I'd be surprised if their administrative budget went up, because that part of their budget tends to stay flat. And if the scientist has to do it, I mean, you all are at a university, they don't like to be told what to do. So, I mean, that would be tough. So I'm wondering, what are these alternatives?
Well, I do think that the NIH could, for example, provide some grants to the Cancer Society and other folks out there that are trying to make this research more understandable to folks. And that, by the way, that does take some effort. Those societies have found that getting a professional writer to be able to take and understand content from primary research articles and make them more understandable is difficult and it's expensive. So I'm just suggesting that if NIH were to decide that that kind of public access and understanding was a critical issue, it would devote more time and resources to those kinds of issues. But I also think abstracts are a good thing, and abstracts are usually part and parcel of every article. So making those more broadly accessible, as is done on the NLM database, I think would be fine.
Just a quick follow-up. Most abstracts are already open access. Elsevier makes its abstracts open access. That's a good policy. We don't need an extra policy to make abstracts open. You're right, though, that if there were to be a lay summary of peer-reviewed research, somebody would have to do it, and there'd have to be some expense there. One publisher objection to the NIH policy is that it diverts money from research into maintaining the open access repository. It turns out that cost of maintaining and implementing the open access policy is about $3 million a year. This is on a $3 billion budget. It's about 0.01% of the budget. And in the same year that NIH spends, let's say, $3 million implementing the open access policy, it spends $100 million paying author-side fees at journals, most of them subscription journals. These are page and color charges at journals where grantees choose to publish. So the cost that, the money that NIH is giving to publishers of subscription journals is roughly 30% larger than the cost of implementing the open access policy. And if we started to pay people to write lay summaries, we would be diverting more money from research into this. And that might be a good use of the money, but if we all decide it's a good use of the money, we should stop complaining that the $3 million is a bad use of the money.
Are there similar policies by funding agencies in other countries that are like the NIH policy that you've been discussing?
Yes.
And how, and if so, how have the publishers responded and reacted to that?
First, there are policies like this in more than 30 other countries. The NIH focuses in biomedicine, and in the field of biomedicine, until last month, every funder open access policy in the world had a 6-month maximum embargo. The NIH has a 12-month maximum embargo. So all these other policies were stronger than the NIH policy. Now Australia joins NIH in having a 12-month embargo on biomed research. So the NIH was the outlier. It was the pioneer. It was the first. It chose a long embargo period, I thought, for political reasons because it reduced the objections. But other countries have been able to adopt stronger policies, and this is tied in with the response to the question of how publishers have responded. It's easier to lobby against open access policies at federal agencies in the United States than in other countries because Congress is open to lobbying. And when Congress adopts a policy, it affects a large body of research. If Sweden adopts a policy, which it has, it affects a much smaller body of research. If the Netherlands does, likewise. So, and Brussels doesn't really control the policies of all the member states in Europe.
Not so much whether the publishers are lobbying in these other countries, but what the effect has been on the publisher's business as a result of these policies in the other countries.
Yeah. Again, we haven't, Mark can correct me, but I don't think we have clear evidence of harm in the form of cancellations. And if we did, I think we would have heard about it by now. Publishers have been asked for it several times.
Most of the policies that have been implemented in Europe tend to have exceptions, and so, for example, there was a policy in Spain which had an exception for publisher copyright policies and the like, so it's not clear what impact those are having. At the same time, at a European level, there's a project which we'll be reporting in May called the PEER project, which is the Publishing Environmental Ecology, something or other, but which is a study that's been going on, I think, for about 2 years, which has actually been conducted in part by the STM Publishing Association with European community funding and researchers at a couple of universities, I think primarily in Brussels in the UK. That project is going to report in May, and the report is basically going to be about taking a look at an open access repository that was built for the project and what impacts could be measured with respect to the downturn, well, any effect on subscriptions. So that comes out in May. We do sometimes worry that politicians tend to not think very much. So we have heard some comments from the Commission which are already suggesting that certain embargo periods should be implemented across Europe without waiting for the result of that project. So these kinds of things do happen, Obviously, we'd like for the lobbyists, the commissioners and the politicians to listen to the study first.
Let me just make a quick concession. Mark is right that some of the European policies are weaker than the NIH policy. Some of them are stronger, partly by having shorter embargoes. The RC UK, the Research Councils UK, which control all the publicly funded research in the UK, are on the verge of adopting a much stronger policy than the NIH. Under the NIH policy, to get back to copyright issues, the work is free online for reading, but under all rights reserved copyrights. There's no freedom for reuse. There are no open licenses. But the RC UK, which already has a policy like the NIH's, is about to add open licenses to its policies and permit free reuse along with free access for reading.
Simon, can I ask if you have any emailed questions that you'd like to contribute? None? Okay. Any other questions in the room? Yeah.
Chris Walsh, I'm a fellow here at the Berkman Center. I'm curious if in the world of academic publishing there have been any experiments with business models that don't rely on controlling access to the underlying work. You wouldn't want to see ad-based scientific journalism because of the corrupting effects, but maybe some value-added commentary or another means of funding that peer review process that doesn't then turn into restricting access to the product.
Sure, there are more than 7,000 peer-reviewed open access journals today in every discipline. I mean, in all disciplines put together. They have different business models. The most well-known business model is used in only about 30% of these journals, and that's to charge a publication fee. The bill goes to the author, but the bill is usually paid by the funder or by the author's employer. And if someone at the author's end of the transaction can pay all the expenses of the publisher, then the publisher doesn't have to charge readers or anybody at the reader side of the transaction. And by the way, Elsevier has some of these journals, and it has some hybrid journals in which some of the articles are paid for this way, and others are paid for the traditional way.
There's also a fair number of society journals that I'm not sure they're exactly monetizing site-to-traffics, but they do value it very much. So it may have some impact on foundation funding or demonstrating the utility of the research to their society and seeking other kinds of funding. So there is a fair amount of that going on as well.
Yeah, I should have said 30% of these journals charge this publication fee, but 70% charge no fees at all, not to the reader side, not to the author side, and they exist on subsidies, sometimes from learned societies, sometimes from universities, sometimes from government agencies, museums, hospitals, foundations, corporations. There are all kinds of models for this. The subsidy model is less well documented, so we don't have a good idea of how many different kinds of institutions participate and in what proportions. But we do know that that's the majority model of open access journals. If you can get a complete subsidy for your expenses, then you don't have to charge anybody anything. I call it the public TV model. They're large expenses, but they're all covered up front so that you don't have to charge the end user. And it's a very common model, and it's growing fast. And conventional publishers like Elsevier, that is conventional in the sense that they charge subscriptions, are experimenting with it and growing the number of journals that make use of these models.
Any other questions? You have one here.
Thanks. So Mark, I had kind of a clarification, maybe a question. So I want to kind of go back to, I think, something you had said. You had said that publishers would be a little more comfortable with PubMed Central if they more clearly identified the author manuscript and gave linkages back to the published version of the scholarship. So I guess what I wanted to point out is that is exactly what PubMed Central does do. Every author manuscript that comes into PubMed Central down the left-hand border has NIH Public Access author manuscript, and there are clear links back to published in its final form as such and such, and links off to the relevant publisher. So I'm wondering if you wanted to comment where you need to see more flexibility in that identification, or...
They don't do that in a very prominent way, however. And there are other respects in which I think they kind of exhibit some confusing information. For example, there's a landing page which talks about journal publishers and journal policies. And it gives, for example, the impression that Elsevier and other commercial publishers don't sort of facilitate or don't participate in the process of supporting manuscript postings. And even in Elsevier's case, we actually submit the manuscripts on behalf of the author. So there's kind of no recognition of that. The only recognition there is for journal publishers that have decided to post or to host the entirety of their journals on PMC. So again, it's not quite even-handed, I would say.
I should add that I completely support the way NIH links to publishers with full citations, and if it's not conspicuous enough, that's a detail to be negotiated. But it was not required in the legislation that Congress passed instructing NIH to adopt this policy that it had to link to the publisher's versions. This was the NIH's idea. I applaud NIH for doing that, and I think any agency that adopts a similar policy ought to link to and cite the published versions of each of these articles. There's no problem with that. It doesn't interfere with open access. It gives publishers credit for all the work that they did. And it proves that the article is peer-reviewed, which you might not be able to tell just by looking at the text.
And you want to give the right citation
That's right.
information in any event. So.
Any other questions? No?
Hi, Phil Malone from the Cyber Law Clinic. First, let me say thanks to all of you for putting this on and sharing all of this with us. It's extremely helpful. Mark, thanks to you particularly for sharing the publisher's view of things and making sure we've got a really balanced treatment of all of it. I just wanted to follow up on Peter's question earlier about where's the harm and try to be sure we have a full picture of that. So we've had a fair amount of time now with the NIH policy, and I heard the talk about the physics and discipline and specialties. Apart from maybe less articles being published, is there any other concrete evidence or indications that you've seen that the NIH policy has impacted publishers in a specific negative way that you can talk about?
Well, I do think physics is kind of an unusual exception, but I think that every community and every discipline is going to be a bit different in different ways. I think it's too early to tell. We are seeing direct impacts, as Peter mentioned, in terms of downloads, in terms of user behavior, in terms of where users are going first. So that does suggest that there is a bit of a traffic issue, if you will, which may translate later to some impact in commercial. But it's early days yet.
Say a little bit more. I'm intrigued by your point about traffic. Can you say a little bit more about what's known about that?
Well, what we see is, unfortunately, researchers in the online environment do not go either directly to PMC or to Science Direct, which is the Elsevier online database. Instead, for some reason, everybody starts with Google. So Google is, of course, the kind of #1 place where people start. But the question is, when researchers do get into a habit of checking different sites, where are they going first? And PMC definitely is drawing traffic, there's no question about that, away from other publishers' sites. Now, there may be a number of reasons for that. So we don't know yet all of the reasons why that may be, but it certainly is concerning.
There are no other questions. Let's thank our panelists. It's been very interesting discussion. Thank you.